appeal in the matter of Hussein and Secretary for the Home Department.
Yes.
Well, good morning, my lord and my ladies, and may it please you. I appear on behalf of the appellant, Mr. Hussein, my learned friend, Mr. Tom Tabori, on behalf of the former Secretary of State for the Home Department.
Thank you.
My lord, my ladies, I'm not sure there are any preliminary issues that I need to deal with. You should have
think
one.
so.
I'm grateful. Should be one hearing bundle, one
Yes.
authorities bundle.
Yes.
That's it.
Yeah.
I'm very grateful. So, if I may, I will proceed to deal with the grounds of appeal that we rely upon. But before I do that, can I make it clear that after some thought, we have decided not to pursue ground
Ground
three.
three. So ground four.
Ground four was. I'm sorry, my lord. I should let you finish.
No, it's all right. Don't go on.
Ground four was abandoned in
Yes.
the permission skeleton argument.
Yes.
And I think it's right to say that we only received permission to appeal in respect to the points we raised in the permission skeleton argument. So that was ground 1, 2, and 3. Ground 3 raises a distinct point,
It does.
and I'm not pursuing it.
Okay. Thank you. Yes.
So on to the grounds I do pursue. Grounds 1 and 2 are closely related, they overlap. Ground 1 is the contention that the hearing before the learned first tier tribunal judge was unfair in a Jones and National Coal Board sense, because the learned judge departed from her supervisory role, as we put it, and therefore lost or risked losing the ability to objectively evaluate the evidence as a judge is expected to do.
Would you I can't think what it is. Would you disagree, rather than supervisory role, but the expression that I've got in my mind is entered into the arena?
Yes,
Is it the same?
it's the same. Different
Right.
ways of making the same point. Supervisory role comes from some of the upper tribunal cases.
Yes.
Entering into the arena comes from, if you like, the fountainhead of this area
Yes.
of law.
Because if you just say supervisory role, you have to think, well, what is the role? How to what what have you done? Whereas if you just say entered into the arena, you know what you're looking for.
Yes, I certainly don't disagree with that, my lord and my ladies, and you will have seen from our skeleton argument that the test we put forward as to whether this principle, however one encapsulates it pithily,
Yes.
has been breached or not complied with. The test we put forward is in terms of descending into the arena,
Thank you.
one's vision being clouded by the dust of conflict, which is the metaphor that's used in the early case law. And having thought about it, I'm not sure I can really improve on that metaphor.
I didn't
think
pick
it
up
gets-
the dust of conflict. Rather like that.
It gets to the heart of the difficulty.
Yes, that
which
sounds
is-
very warlike, doesn't it? In the sense that. Anyway, okay,
Well,
sorry,
Learned Friend
I'm
and I,
interrupting you
sure
too
won't be
much.
warlike, but sometimes proceedings
Yes.
in court can descend to that
Yeah,
degree
okay.
of adversarialism. But yes, I mean the essential principle, and I'm in dangerous territory in trying to improve on the metaphorical expression that we've looked at. But the essential principle is that a learned judge's role is to be an objective judge, and that role is incompatible with descending into the arena or getting involved in the evidence, to put it colloquially, because there's an undue risk that if that happens, or there is a risk that if that happens, the judge will become too close to the issues between the parties and will therefore be unable to discharge the objective role of a judge.
Sorry, can you say that again? Get too close to.
Too close to the issues, to the points of controversy, and will therefore risk at least being unable to properly adjudicate those issues in an impartial and objective fashion. I think that's a fairly accurate way of expressing the underlying principle, but as I've said,
Sorry, being properly being. Wait a minute. Get too close to the issues and will therefore be at risk of being unable properly to adjudicate those issues in an impartial.
in an impartial and objective way.
Thank you. Sorry, I just wanted to get that down. Thank you very much.
As I respectfully see it, that is how that is the underlying principle in respect of the metaphor that we looked at and the authorities. But we'll look at the authorities because my word doesn't matter very much. What matters is what's said in the case law in respect of this. And we will go through a couple of the authorities. So what I propose to do in respect of ground one is just to quickly look at some of the key authorities, just so we're absolutely clear about what the principle is and how it operates. And in the course of that exercise, I want to look at a couple of authorities on the role of the tribunal in this case, whether the tribunal is an adversarial tribunal, if you like, or more inquisitorial, because I think that's a point that's taken against me, that when one's dealing with statutory tribunals, the function of the tribunal is not necessarily equivalent to a traditional adversarial proceeding. We say that's not right in the immigration context, at least as a generality, and certainly not in the type of case that we're dealing with. And then I'll deal with the evidence, if I may, including the transcript, and make references to aspects of that evidence that show we respectfully submit that the learned first-tier tribunal judge did descend into the arena in a way which was impermissible in the light of the Jones and National Coal Board principle. And I'll also explain how that seems to have had an impact on the judge's reasoning, because a point that's taken against me, I think, is that it's not enough to show that there was some risk of unfairness. One has to show that the proceedings were rendered unfair. I'll say a little bit about the correct approach in principle to that proposition. But we say that in this case, there are indicators that the learned judge's evaluation of the evidence was affected by the fact that she descended into the arena. Then I'll look briefly at the upper tribunal's decision, and then if there's anything to respond to at that stage in respect to the respondent's arguments, I will deal with that. And then I'll turn to ground two, which I can deal with much more quickly. So in respect of the key legal principles, I think the starting point has to be the Jones and National Coal Board case. That's at tab 19 in your authorities bundle if you're using hard copies. If not, it's page 535. That's where it begins. So tab 19, page, sorry, did I say 535? That's my note being inaccurate. It's 3, 5.
Sorry, hold on. 19.
Tab 19, if you're
Yes.
using hard copies.
Yes.
Tab 19.
Thank you.
The relevant passages are internal page 63, going all the way to 65, and those begin on page 361 of the bundle.
Yes.
So I think it's helpful to start on page internal 63, 361. First point to note in that middle paragraph, first sentence, this is part of the context of what Lord Denning is about to say.
Yes.
It's recognised in that sentence that there's no fault on the part of the judge, there's no bias or apparent bias. No one can doubt that the judge, in intervening as he did, was actuated by the best motives. So we're not dealing here with any level of impropriety or any species of impropriety. In the next paragraph,
Sorry, and he just to note, he also went on. He was anxious to understand. This is the judge. He was anxious to understand the details of this complicated case and asked questions to get them clear in his mind.
yes, my lady, I'm very grateful. And that's very helpful, if I may respectfully say so, my lady, because that is one way of understanding what the learned judge in the first-tier tribunal did in this case. We say that doesn't mean that the learned judge did not descend into the arena in a way which resulted in unfairness. And that seems to have been the context in the Jones case, at least in part. So we then get to the next paragraph beginning, nevertheless, we are quite clear that the interventions, the far more than they should have been. And that is effectively our case in terms of the overarching submission we make. in respect to ground
Can I
one.
just pick up the use of the word interventions?
Yes.
I haven't read this for the purposes of this hearing. Can you remind us where it set out what the complaint was as to the judge's, the manner of the judge's interventions? And I think we find it on page 60, don't we? The judge's interventions during the examination in chief and re-examination was so extensive, were coextensive. Is that it?
Yeah, I think the essential, both parties in this case actually appealed and presumably cross-appealed on the basis that the learned judge's conduct of the hearing rendered the hearing unfair, both in respect of interventions during the course of cross-examination and interventions during the course of examination in chief.
But it was interventions in the course of the witnesses giving evidence.
That's how it was put in the case.
Right,
and
okay.
the subsequent,
But I mean, just to see the context, if one looks at pages 62 to the top of page 63,
yeah,
there's a summary of what the judge did in this case, and it seems to be quite a lot more interventionist than what we have in this case.
that's it. Well, yeah, I think that.
So,
I mean,
if you look halfway down page 62, he took the examination of the witness out of the hands of leading counsel for the rest of the day and of his junior counsel next morning.
I'm very grateful, my lady. Yes,
Mr. Miles Jones then cross-examined the witness, but during the cross-examination, the judge intervened on several occasions to protect the witness from what he thought was a misleading question and to bring out points in favour of the witness's point of view. And then we get a description of what happened with the next witness. Examination chief, normal. During Mr. Miles Jones' cross-examination, the judge seemed afraid that he was being misled, intervened at considerable length, and in effect stopped his cross-examination on the important point of chops. When Mr. Edmund Davis re-examined, the judge cut him short, saying, "This is what has been given again and again." And then there's a description of the surveyor's evidence, nothing untoward in his evidence. Then the expert consultant mining engineer. We're afraid the judge took examination in chief largely out of the hands of Mr. Edmund Davis. He took the points of criticism made against the defendants, went through them with the witness, and appeared to accept his explanations. Mr. Miles Jones cross-examined the witness, but after a while the judge disclosed much impatience with him, and he brought it to a close. So that's what happened in that case.
I'm very grateful, my lady. That's right. And obviously this is a fairly extreme example. And that's been commented upon in subsequent cases. But to go back to my Lord's point about the word interventions, in the context of litigation at the time of this decision in Jones, proceedings were perhaps more adversarial than they are now to some degree. And I think the word interventions has to be looked at in that context, because as my lady points out, in certain respects, the learned judge took the handling of witnesses out of the hands of the advocates altogether by conducting his own examination in chief.
Well, I think if you did that now, you would be open to criticism.
Yes, yes, absolutely.
Because it's the point that's made in a number of cases that the parties must be allowed to present their case, their evidence,
That's right.
in the manner in which they want to.
That's right, my lord. I simply make the point that the word interventions perhaps wouldn't be used in if this sort of situation arose today.
Okay.
You can see the extent of the descent into the arena, if I can put it like that, in that particular case. Effectively taking examination in chief of certain witnesses out of the control of the responsible advocate, essentially pursuing cross-examination or interfering with cross-examination with great respect. So it's not just cross-examination or interference with cross-examination, it's also examination in chief. And then to go back to page 63 internal, page 361 of the bundle, and that passage we were looking at a few moments ago, nevertheless we are quite clear.
Yes.
I mean, I think the key passage in this decision is really the entirety of the paragraph beginning, nevertheless, we are quite clear,
Right.
all the way down, I'm afraid, to the bottom of page 362, probably the first part of the paragraph saying, such are our standards. It's a beautifully written piece of judicial judgment craft, if I can put it that way, so it's not too much of a burden to read it. But
And there we have descends into the arena and is liable to have his vision clouded by the dust of conflict.
that's it.
Yeah.
And the reason I emphasise this chunk of the judgment, if I can respectfully put it like that, is that it's clear here that the court is not looking at interventions in cross-examination, it's looking at the whole picture, whether whether the judge has descended into the arena such that their objectivity has been risked, if I can put it like that, by the dust of conflict. And there's a nice expression in respect of that principle towards the bottom of page 362. I think it's 6 lines up from the beginning of the paragraph that says, such are our standards.
Mhm.
If he goes beyond this, he drops the mantle of a judge and assumes the robe of an advocate, and the change does not become him well. So this is what the principle's really about. It's about losing that role, departing from one's proper role as a judge. And then on page 16...
I mean, I think, sorry, go on.
No, you have to.
I think that's what entering into the arena means, doesn't it? It's assuming the role of an advocate.
I think that's right. I mean, we're dealing here with a number of different metaphors to try
Yes,
to
we
capture
are.
the underlying principle. But I agree.
Thank you.
But also, I think it's important to note in the middle of that page, that's page 64 of the authority itself, just after the reference to the Queen and Clua. The judge's part in all this is to hearken to the evidence, only himself asking questions of witnesses when it's necessary to clear up any point that has been overlooked or left obscure.
Yes, my lady. And I've highlighted, I mean, this is part of the passage that I
Absolutely.
highlight. So,
Mhm.
and I'm conscious of the time, and I didn't invite the court to go through it carefully and read it in full now, but in due course, this passage will need to be carefully evaluated by the court. And then we get to page 65 on page 363,
Yes.
and I don't propose to go through this in as much detail, but essentially what we see in the line marked passage is a particular appreciation for the risk to the fairness of a hearing in adversarial proceedings if a judge interferes with cross-examination. And that aspect of this wider Jones principle of not descending into the arena, not interfering with cross-examination, has been picked up in a number of subsequent cases. The submission is that the Jones principle is by no means limited to interventions in cross-examination. It's a much broader principle, and it requires an evaluation of the totality of the proceedings before the learned judge to ascertain whether the learned judge has descended into the arena, etc.
But these principles don't prevent the judge from clarifying the evidence. If you look at the third long paragraph on page 65, 1, 2, 3, 4, 5, 6, about 6 lines down, the sentence beginning, now it cannot. So it is open to the judge, if he feels that by reason of the technical nature of the evidence or otherwise, it is only by putting questions of his own that he can properly follow and appreciate what the witness is saying.
Yes. So clarificatory questions, that's the category I would put that sort of intervention under. So of course a judge can ask a question in order to clarify evidence, because that's compatible, with respect, obviously compatible with the judge's proper function as an objective fact finder. But going beyond that and choosing how the evidence should develop, pursuing one's own line of questioning and interfering in cross-examination is not compatible with the proper role of the judge.
Because most of the passage on page 65 is dealing with the submission that the judge interrupted cross-examination too much, so that essentially it lost its effect and the importance of allowing counsel to develop along, a sequence of questions.
Yes, and that's picked up in subsequent cases, in particular the Serafin and Malkowitz case.
But I mean, that's not a criticism here,
No.
because the judge didn't intervene in
That's right.
cross-examination.
But I hope I've been clear, my lady.
Yeah.
The observations on page 65 are dealing with a particular, if you like, subcategory of circumstance in which this principle that the judge should not depart from their proper role and descend into the arena has real purchase. There's particular risk in respect of interventions in cross-examination for all the reasons that Lord Denning sets out on page 65, but the principle is not confined to such interventions. It's a much broader principle. And that's why I asked the court to look at the passages that I referred to on pages 361 and 362 of the authority standard. So that, I think, is the fountainhead of this area of jurisprudence. We also have the Ewell and Ewell case in the bundle if you want to look at it. But interestingly, that case did not concern unfairness. It was concerned with the extent to which, on appeal, an evaluation of a witness's demeanour could be interfered with. But it is the first time that this idea of descending into the arena and having the judge's eyes clouded by the dust of conflict. That's the first time that that metaphor is used, but it's subsequently picked up in the Jones case by Lord Denning, and we've looked at the relevant passages in that decision. There are a number of authorities that look at this Jones principle. I think it probably will help to go through hint authorities.
Yes.
I'm very happy just to give references if the court
No, let's take us through them, please.
insisted.
Yes.
So I think the next, if we just deal with this in broadly chronological order, the next authority is Southwark LBC and Kofi Adu, which is at tab 15. So this civil litigation is of housing, and I think a possession order, and rent arrears. The facts are not particularly significant. What's more significant is the way that the court dealt with the argument that the proceedings in that case were unfair because the judge descended into the arena. And we see the relevant passages in that respect at paragraph 142 to 147. Those begin on 307, page 307.
Yes.
And you'll see on page 142, there's a quote from Lord Denning's judgment in the Jones case that we just looked at on page 63. There's a lot one could quote from Lord Denning in that passage, but this is the quote that the learned judge fixed on here. And you see a further quotation on paragraph 143.
Yes.
And again at 144, there's a quotation from the Ewell case, which is a helpful originator of the metaphor, if you like. But
Yes.
as I said, the Ewell case actually didn't deal with this sort of unfairness. And then, interestingly, paragraph 145. There's a recognition that proceedings in the modern context can be more interventionist or more inquisitorial, if you like, than was hitherto the position, but it's recognised that nevertheless the Jones principle applies. it remains the case that interventions by the judge in the course of oral evidence, as opposed to interventions during counsel submissions, must invariably carry the risk. So graphically described by Lord Green, the greater the frequency of interventions, the greater the risk, etc.
That is clearly directed to in the course of, and using interventions in that sense.
In the course of oral evidence.
Yes.
I think that last part of the sentence, and where the interventions take the form of lengthy interrogation of the witnesses, the risk becomes a serious one. Well,
Yes.
with respect to the first tier tribunal judge in this case, that's exactly what happened. And then we have at paragraph 146 a helpful statement in my respectful submission of the test, or something close to the test. The risk of unfairness does not depend on appearances or what an objective observer might think. So the point that's being made here is we're not dealing with principles in respect of apparent bias or actual bias, McGill and Porter and McGill. Rather, the risk is that the judge's descent into the arena may so hamper his ability properly to evaluate and weigh the evidence before him as to impair his judgment, and may, for that reason, emphasis in the original, render the trial unfair. That's the principle in my respectful submission.
But it is an objective assessment.
Absolutely.
Yeah, it's not the objective observer is talking about bias,
Exactly.
but the assessment as to whether or not the interventions have rendered the trial unfair is an objective assessment.
Yes, my lord.
Yeah.
And that's the position we've taken in the written argument.
It is.
By reference, I think, to this passage. But I would emphasise as well, so objective test for the court. So objective test means one objective right answer in my submission. May be important when it comes to looking at the upper tribunal's decision in this case. But the test is importantly different from the hypothetical reasonable observer
Yes.
test.
Yes.
The other point I would emphasise from this passage.
Can I just, picking up the point that you adverted to earlier on, may for that reason render the trial unfair. Are there two elements? One, excessive intervention, and secondly, they have rendered the trial unfair, or is it that the one inevitably leads to the other? See what I mean?
Well, this is the point I was just about to make.
I'm sorry.
Not
Yeah.
at all. It's the latter. That's my submission, and that's the proper interpretation of paragraph 146, and the emphasis in that last part of the last sentence for that reason. So in my submission, I think it's it's Lord Justice Jonathan Parker. What Lord Justice Jonathan Parker is saying, in my respectful submission, is it's the risk of a loss of objectivity or something along those lines. It's the risk of whatever it is that descending into the arena cause that triggers the unfairness. Now, I appreciate in other authorities, the courts have looked to whether, despite interventions that were to some degree thought to fall foul of the Jones principle, the overall proceedings were fair, and one can readily understand why the court would do that. But in my submission, in principle, the Jones principle is correctly stated at paragraph 146. So if the Jones principle is contravened because of the judge's descent into the arena, it's the risk that that may so hamper the judge's ability properly to evaluate the weight and weigh the evidence before him, so as to impair his judgment. That is what renders the proceedings unfair. It may not matter much in this case, because in due course I will try to show that actually the descent into the arena that we see in this case did seem to affect the learned judge's evaluation of the evidence. have my submission on the principle. The next authority that we perhaps should briefly look at is the Supreme Court decision in Serafin and Malkowitz, which is at tab 8. And it's fair to say that this was a fairly extreme case. It involved a litigant in person who seems to have been treated inappropriately to some degree by the learned judge. And held that the Jones principle had been contravened on the facts of that case. The relevant legal principles are helpfully analysed from paragraph 37 all the way to paragraph 46. So that's a set of passages begins on page 162 and ends on page 165.
You don't want us to read all of that,
Not
do
at
you?
this stage.
Do you want to draw out any particular elements?
Well, I'm just double checking whether I want to or not. I don't think this is a very helpful analysis of the authorities to date.
Yes.
We've looked at the key authorities already. I think probably worth having a brief look at paragraph 40 for the sake of my oral argument.
Yes.
Just again, a recognition of the Jones decision still being the leading authority. And you've got a helpful summary of what happened in Jones, consistently with my summary of the decision. Both sides complained that the extent of the judge's interventions had prevented them from properly putting their cases. But there's a reference in particular in paragraph 40 to the problems that can arise if there's an intervention in respect of cross-examination. But as I've explained, the Jones principle goes beyond that. So, my ladies and my lord, you have these passages. They're a useful summary of the previous case law. I'm not sure they add a great deal to the principles that we have looked at already in the two authorities that we've focused on so far. We then get to a decision of the upper tribunal.
Before we go there, at 41, there's a consideration of Southwark.
Yes.
I'm in Serafin, and towards the end of that paragraph, it's being said. Trial judges at the top of the page nowadays tended to be more proactive and interventionist than they were in Jones, and that the observations of Lord Justice Denning should be read in that context, but that their interventions during oral evidence continue to generate a risk, and this is the point about the risk in them, how that's to be evaluated,
Yes.
of their descent into the arena, which should be assessed not by whether it gave rise to appearance of bias, etc., but whether it rendered the trial unfair. And that seems to be a recording of Southwark, which suggests that you've actually got to decide whether it did actually render the trial unfair. I just wonder what you could say about that.
Thank you, my lady. I had read paragraph 41 as effectively mirroring what I had already submitted by reference to Southwark. But I take the point that last part of the last sentence of
Yes.
paragraph 41, on one reading, suggests that there needs to be an evaluation of unfairness.
Mm.
Now, we've looked at paragraph 146 in Kofi Adu, which is what paragraph 41 of Serafin is effectively trying to summarise.
Yes.
And you have my submission in respect of that paragraph. On a correct reading of that paragraph, it seems to be, this is my submission, that the Court of Appeal is making the point that it's the risk of unfairness, that it's the risk that is caused by the descent into the arena that generates the unfairness. And I think that is compatible with the last part of paragraph 41.
Okay.
What the last part of paragraph 41 is doing is setting up the distinction between the test for apparent bias and the test for this kind of procedural unfairness.
Mm.
And of course, that is perfectly consistent with Kofi Adu. Kofi Adu, paragraph 46, does not suggest that you look at whether somehow descending into the arena has been cured or didn't cause unfairness in some nebulous broader sense. And of course, the term unfairness is not particularly helpful, with great respect, because it can mean a lot of different things in different contexts. The unfairness in this particular context is caused by the risk to the judge's ability to perform the role of a judge properly, objectively, to assess the issues and the evidence that is caused by the judge descending into the arena and donning the robe of the advocate, or whatever metaphor you want to use. So that is the unfairness that is the subject of the Jones line of cases. And once that unfairness has been demonstrated, that, in my submission, should be sufficient. There may be occasions where the courts, and I think there are, there may be occasions where the courts can say, well, okay, perhaps the judge went too far, but overall, we're not prepared to intervene because we're satisfied that the integrity of the proceedings were not seriously enough undermined. And I can understand why the courts would adopt that approach in a given case, but the principle is correctly stated in 146 of Kofi Adu in the way that I have submitted it. I would respectfully submit.
Can I test that? Because, as I think you just alluded to, a judge might descend into the arena for a brief period.
Yes.
But that descent into the arena doesn't render the trial unfair. So you've got to have, I mean, this is, Lord Wilson does use the word whether, which is quite, but by whether it rendered the trial unfair.
Yes.
And a careful man with his words. Because it needs to be a sufficient descent into the arena as to render it, because there's always a scale. You know, you might have occasions during when the judge did improperly intervene with the cross-examination or sought to protect a witness, whatever it might be, as it's described in some of the cases.
Yes.
But overall, the impact on the evidence was not sufficient to render it unfair.
Yes, my lord, I would agree with that. And I think
Right.
that follows from the need for the objective assessment.
Yes.
You objectively assess whether there's unfairness because, if you like, the risk of the judge being unable, objectively speaking, the risk of the judge being unable, objectively speaking, to perform their proper function.
The test is unfairness,
has been
isn't
triggered.
Yeah.
So there's a threshold,
Yeah.
and there's a need for an objective evaluation of the circumstances. But once that threshold has been met, following that objective evaluation, then there's unfairness. So I'm very grateful. I think that probably is that nuance does need to be.
So
that refinement is necessary to my submission. Yes.
sorry, I was about to intervene.
I'll forgive you, my lord.
Thank you. A threshold in the sense of sufficient interventions, however you want to call it, to render it unfair. I don't want to get over sort of over analytical
I
about
think there's
this.
a danger of being of adopting too many fine distinctions. The test is an objective one.
Yeah.
The basis of the unfairness is the risk that the judge is unable to perform their proper function, and that requires. So you look at all the relevant circumstances to determine whether that risk has arisen. That's one way of looking at it. But what you don't do, in my respectful submission, is say, well, the risk has arisen, but we can see that the evidence was very damning, or that overall the judge produced a impeccable decision. If one just looks at the judgment, that's not what you do. And in fact, I think that's consistent with what the Supreme Court
Did in
says.
Serafin. Yeah.
Yeah, says at paragraph 44. and perhaps elsewhere in Seraphim, by reference to the G case. That last sentence of paragraph 44 on page 163. As I think Lady Justice Black said in G, careful and cogently written judgment cannot redeem a hearing in which the judge had intervened to the extent of prejudicing the explanation of the evidence. So that may be another way of trying to get at that concept.
Yes, to the extent, that's the threshold.
Threshold
again.
of risk.
Yeah. Well, yes.
I'm very
It's whether it's a risk or eventuation. That's the word, because it's a risk of prejudicing,
yes.
not a. I mean, sorry, extent of prejudicing, not the extent of creating a risk of prejudicing. Sorry to go back to that
Not at all.
point. Anyway, I understand your
Well,
submission.
I think prejudice, it to the extent, we don't have the G case unfortunately, but the extent of prejudicing the exploration of the evidence, I mean that's perhaps an ambiguous expression. It's not stated that the evidence was that the factual findings were undermined or unreliable. There was a prejudicing of the exploration, and I think so that's going to risk that the sort of wider risk that the forensic process has been undermined to some degree or rendered unfair. So I think that passage is compatible with the submission that I put forward.
Thank you. Yes.
But I'm very grateful, Lord. The next authority, and there are other authorities in the bundle, but the next authority that I'd like the court to look at briefly is the Elias case, which is at tab 5. It's a decision of the upper tribunal, Immigration and Asylum Chamber, so it's close to home, so to speak. It's at page 65 if you're using electronic. And there's a helpful summary of the authorities to date, including Seraphim, in 2 locations. Paragraphs 25 to 26 on page 71. So this is consistent with the principle that there's an objective assessment rather than an apparent bias type assessment.
Yes. Yes.
And then at paragraph 32 to 37, beginning on page 72, there's a further review of the authorities which we've looked at. And helpfully at paragraph 36, there is reference to a decision of the upper tribunal IAC in a case called WA, role and duty of judges.
Yes.
And this is where we get the reference to supervisory role.
Yes.
We've got WA in the bundle. I don't propose to take the court to it during the course of my oral argument. I think it's probably adequately summarised here for my purposes. And then we get a paragraph 37 of the upper tribunal summary. In summary, interventions that stray beyond the merely supervisory role of a judge during taking of evidence risk a judge descending into the arena and clouding their vision by the dust of conflict. We respectfully submit that that is what's happened here. Finally, on this journey through the authorities, Keane and Sargan, which I think is the most recent authority on point in the bundle, it's page 17 if you're using electronic, tab 2.
There's a tension between, in my, speaking for myself obviously, between the expression merely supervisory
Yes.
and what's said in the other cases about it's perfectly legitimate for the judge to explore, to seek clarification, which you might say is more than merely. I mean, merely supervisory is a pretty modest description of the role of an adjudicator.
I see that. And I think in fairness to the panel, I think it was a panel in the Alias case that we've just looked at, I think the panel would agree with you as well. We have in the bundle some of the earlier authorities in respect of judicial interventions in the context of immigration appeals.
Yes.
And they recognise quite clearly that a judge can intervene in order to clarify, in order to properly I'm just trying to use the right word. In order to act as an impartial referee, if you like, to the taking of evidence.
And that's clear also from the quotation in paragraph 36 of Elias, where it says, when both sides have finished their examination, he may ask questions of his own by way of clarification.
Grateful.
And give an opportunity, of course, for both sides then to ask further questions.
Yes. In particular, I think it's the XS case at tab 16. I don't propose to take the court to it now, but it's XS at tab 16, page 311. Decision of Mr. Justice Ousley and two other judges of the Immigration Appeal Tribunal, as it then was. And there's guidance given in that judgment as to the role of a judge. Similarly, in the JK case, which is at tab 17, another decision of Mr. Justice Ousley, he was president at that time of the Immigration Appeal Tribunal. Paragraphs 42 and 44 on page 336 to 337, where the learned judge looks at, if you like.
Sorry, I was just looking at excess. I'm sorry, I got distracted a bit. Because I thought there was was it somewhere in this, or was it another decision of his where he referred to it's fairer for the adjudicator to explore factual issues about which they're concerned, than to keep silent. Is that in excess, or was that in a different one?
I think that's probably JK.
Is it JK? Is that where you're going to next?
That's where I was just. I was
Sorry,
dealing with this perhaps too quickly because I didn't propose to take the court to it, but given the question.
I think it may be JK at paragraph 44.
Which tab is JK?
So JK's tab at 17, my lord. And
Thank
the relevant
you.
passages, they have been helpfully line marked, paragraph 42 all the way down to 44 on page 336. 42 starts on 336, going over to 337.
Sorry, which paragraph starting 42?
So you've got the line marking. It's what's line marked.
Sorry, I have. Yes, thank you. Yes, this was what I was thinking.
So, for example, second part of paragraph 43, the sentence beginning, however, it is wholly legitimate.
Yes, there we go. That's what I had in mind. Thank you.
But then this at the end of the passage. However, what is important in relation to those matters is that the adjudicator should not develop a different case from that being presented by the other party or pursue his or her own theory of the case. So again, we're getting at that line between the proper function of a judge and the proper function of an advocate. And then at 44, there's reference, there's other observations as to where that line can be crossed. And I think my lady may have in mind the passage, I think it's 10 lines up from the bottom.
Of 44.
44 on page 337. An adjudicator is entitled to follow the logical train of answers to see how they fit with the case. If that is regarded as potentially significant for an issue in the case. Also important, however, that an adjudicator can keep a sense of proportion, not for the adjudicator to take over control of the case, either by the number of questions asked or the development of his or her own theories. The interventions may or may not assist one party. They are not unfair merely because the other party may derive assistance from them. So again, in my submission, what Mr. Justice Ousley is getting at here is where to draw the line. But ultimately, the line has to be drawn by this court, applying the test in Kofi Yadu at paragraph 146, that's my submission, and the Jones principle in respect of not descending into the arena, applying that objective risk-focused assessment in 146 of Kofi Yadu. So that's Elias and the way that the tribunal has dealt with judicial interventions and questioning in some of the earlier authorities. We were in Keane and Sargon, and I don't think we need to spend much time on this. So this is tab 2 of my ladies and my lord. I think we're just in it, and the relevant passages.
Sorry, I missed that again. Can you tell me?
Keane and Sargon,
Tab
tab 2.
2.
The relevant passages begin on page 35, paragraphs 55, all the way to 66 on page 39. It's been line marked, so my ladies and my lords have that marking and can look at these passages in due course. I don't think there's anything in this that's inconsistent with my analysis. Save perhaps, but it might be worth looking at paragraph 59 on page 37. So there's reference there to the Jones principle by reference to a case which we don't have in the bundle, I'm afraid, called Michelle and the Crown. And the point that's being made in paragraph 59, but my ladies and my lord will need to look at the passage in full, is that excessive interventions might not necessarily mean that, as I would put it, the threshold of risk has been reached. Might not necessarily mean that there's unfairness.
Right, yes.
And there's reference to another case we don't have in the bundle, Shaw and Rowby.
Well, that ties in with your threshold point.
That's how that's the submission, that this is consistent with the need for a threshold, but what this does not show is that you can effectively cure this form of unfairness if it's arisen by looking at what ultimately happened. But I suppose it might be said against me that that last sentence of paragraph 59, by reference to the judgment of Lord Justice Patton, Shaw and Grolby, might indicate a different approach. Allegation of unfairness requires one to look carefully at what were the real issues in the case and how the judge's conduct impacted on them. That's not entirely easy to square with the other authorities we've looked at. But if all that's being said there is the court has to conduct its objective evaluation of whether the threshold of risk has been reached, then there's no difficulty. So those are the authorities that, in my respectful submission, provide the most assistance to the court on the Jones principle and how it operates in this area. The other legal topic that I wanted to deal with before I get into the evidence in respect of ground 1 it concerns the nature of the first tier tribunal's function, and in particular whether the first tier tribunal is an adversarial tribunal in the instant context. Now, my learned friend relies on the MN case, which is at tab 12, page 221 tab 12. This is MN Somalia and the Secretary of State for the Home Department in KY Somalia. It was a case about guidance that the upper tribunal could give in respect of expert reports
Yes.
called SPRACAB reports that could be used to determine where a person may have come from. And in that context, of paragraph 25 on page 232, page 232, paragraph 25, Lord Carnworth highlighted that in tribunals, under the current tribunal scheme, statutory scheme for tribunals, there's no presumption that the procedure will necessarily follow the adversarial model. And an example is given of social security cases. And then at the end of paragraph 25, we see this. However, there is no single approach suitable for all tribunals. For example, in a major case in the tax or lands tribunal, the sums may be as great and the issues as complex as in any case in the High Court, and the proceedings will be modelled accordingly. Now, in the immigration context, it has long been accepted that proceedings are adversarial, with the potential caveat that in asylum cases, there's a degree of inquisitorial context because of the issues in asylum cases. But that's not the context of the instant case. And so if we start with a case called Demeter at tab 18, this is a very old case by immigration lawyers' standards from 2000, March 2000. The issue in the case was whether it was procedurally improper for a first-tier tribunal judge or an immigration adjudicator at the time, I think, to adjourn a hearing of their own motion to allow for the Secretary of State to be represented. And in considering, and it was held that that was procedurally improper, and in considering what should happen next, and in particular in evaluating the submission, I think Raza Hussain, as he then was, made, that the case should be remitted, but there should be effectively an injunction preventing the presenting officer from attending, which, with great respect to Mr. Hussain, is a bold submission, but it was the argument. That argument was rejected for reasons given at paragraph 22 and 23. 22 begins on the bottom of 350. The key passage, for my purposes, has been line marked on page 351. The appeal should be and is adversarial. It is important that the special adjudicator should avoid, if possible, giving any appearance of entering into the arena by challenging the account that the applicant gives. To that extent, there's an important determination of the President, then President, Mr. Justice Collins, in the case of, I'm not even going to try and pronounce it, I will mess it up, but that is an unreported decision. I haven't been able to track it down, but you've got the passage there. The beginning of this report makes it clear that that decision is unreported. And we rely on that passage from the unreported judgment as well. So this is an early recognition, relatively early recognition, that immigration tribunal proceedings are very much adversarial. And that aspect of the Demeter case was applied cited and applied with approval in my submission. In the Scots case of HA and another behind tab 14. And the passage where that aspect of Demeter is cited and applied is paragraph 13, it's page 264. And finally, the guidance given in the line mark passage in the HA case, including paragraph 13 that we've just looked at, was applied by this court in the Abdi and others case, which is at tab 1. In particular, paragraph 29, so tab 1, yes, page 11 of the bundle, paragraph 29. I think it's fair to say this passage doesn't use the expression adversarial proceedings, but paragraph 13 in HA is referred to. So the headline in respect of this set of authorities in my submission is first tier tribunal proceedings are adversarial generally, and the instant case was a particularly adversarial case because the Secretary of State had made an allegation of fraud, effectively, allegation of dishonesty. So, my ladies, my lords, those are the authorities that I want to refer to in respect of ground 1. Can I turn then to the evidence? I don't ask the court to turn it up now unless it would assist, but we have a witness statement from the advocate who appeared before the first tier tribunal, page 65. It refers to in the written arguments.
Yes.
In particular, paragraph 3.
I'm not sure that really helps. Does it really? Because it's an objective assessment. Does it really help us to?
Well, I've thought carefully. One of the points I make about ground 2 when I get there is that the evidence of what an advocate did or did not do, the fact of what an advocate did or did not do, is of limited relevance in respect of the objective assessment that we're dealing with. And I think that that logic would carry over into the value that one can derive
I mean, it's
from a
two.
witness.
Yes, I mean, on the first point, in my view, some of the questioning can properly be perceived as amounting to cross-examination. Isn't that really a matter for us to?
It is. The reason that this might be relevant and might be of some assistance is that, as Lady Justice Andrews noted when granting permission, and as we have submitted in writing, a transcript can never tell the whole story or paint the full picture, because one communication is more nuanced than simply what's written down on a page, particularly in the context of adversarial proceedings and examination of a witness.
Except that this was a remote hearing, so, I mean, would you accept that some of the nuances that can be evident when everyone's in the room together are a lot less
Well,
evident when it's
it's
looking at phones and screens and things?
it can be a challenging forum, a remote hearing. It is different from face-to-face hearing, from a face-to-face hearing, but one is still receiving a lot more information than simply what's written down on a page. You get to see the witness. That's why it's a video hearing and not just a telephone hearing. You're able to hear the witness, which obviously you can't do through a transcript.
Or
So
not as the case may be,
Or-
because if you read
right.
this transcript,
Or
there's a
you
lot of
look at someone's ear for
yes.
extended period. So
But you don't get tone
well,
from reading a transcript.
no, exactly,
we're-
exactly. So there's a lot of audio information, as you say, tone, speed, various things that you just don't get. And you don't get visual clues. I mean, the Ewell case, interestingly, was all about demeanour, for example. You don't get anything like that from a written transcript. But I appreciate my lady's point. A remote hearing has its own features.
Remoteness.
Exactly. I would respectfully suggest that a remote hearing is far less effective as a means of communicating with judges and witnesses than a face-to-face hearing. But that's not to say that those that style of or form of hearing is not fair, but it is different. But it's been recognised in the authorities, and I think my learned friend relies on one of them, that because transcripts are limited in what they can convey, there is scope for looking at wider context. And the case my learned friend relies upon is the Beswick deceased case, which is at tab 7. And the relevant passage is paragraph 27 on page 140. So this is behind tab 7, paragraph 27, beginning on 140. And what my learned friend relies on this passage for, I think, is the potential significance of a decision by an advocate not to intervene and object to a judge's questioning. And the reason that we learned, I think, High Court judge, circuit judge in that case, thought that piece of, if you like, circumstantial evidence was relevant, was that the transcript only conveyed limited information. That's clear from 8 lines up from the bottom of page of paragraph 27. So if you just look at paragraph 28 on page 141 and go up 8 lines or so.
Sorry, right.
It's
Yes.
Sentence, it's worth remembering that a transcript tells one nothing of timing, rhythm or tone, etc.
Yes.
I think all of those points would apply even in respect of a remote hearing. So for that reason, that transcripts convey limited information, evidence from an advocate as to what happened and their assessment of things like tone and approach and appearance, if you like, is potentially relevant. And we have some limited evidence in the form of the advocate who appeared below's witness statement. But the key evidence is the transcript.
Yes.
And that's the position we've taken right into the position I take here now. Now, in the interest of timing, I don't propose to take the court through every aspect of the transcript. I can give the court the key references. I mean, I think the reality is the court will need to go through the transcript.
You did that in your skeleton. Are those the passages you want to go to, or if you want to go to other
There are a
ones, can
couple
you?
of other passages.
Okay,
So you've
then.
got. I don't propose to repeat what I've said in the skeleton argument.
I actually thought I couldn't entirely follow them because I think you're referring to internal transcript page numbers,
Yes.
and we don't have those.
Yes.
So can we just check that because you start with page 11, lines 12 to 29,
Yes.
and I think that's page 88.
That's right.
Am I right about that?
That's right, my lord.
And I couldn't even find 12 to 20. I wasn't sure that it was 12 to 29. Can you
The
check?
line mark. It's unfortunate, but for some reason even the line markings are different. as
Okay.
well as-
So can you just confirm, if you would, what you were referring to in your skeleton, and then obviously the additional ones you want to take us to.
Thank you, my lord. So, in respect of what we see on paragraph 30 of my skeleton argument, 31, so that's the first example we give.
Yes.
Where?
This is bottom of page 6 of my skeleton argument.
Yes, but in the transcript, where am I?
Yes, I'm just about to go there.
Sorry.
If you just bear with me.
I'm so sorry.
Not at all.
I think it's page 87, line 34.
I think that's right.
Because that's where did why did Mr. Islam go with you?
That's right.
And then it goes,
Yeah.
oh,
So it
oh.
starts at 30, exactly, line 34, bottom of 87.
and then middle of page 88, line 14. No, he didn't take the test. Thank you.
And then the other example, this is subparagraph 2 on page 7 of my skeleton argument.
Yes.
I think one can find that reasonably easily. It follows on 2 pages along or
Page
so.
90,
Yes.
line
Confirm.
6. Just pause there for a moment.
Yeah, that's it, my lord. I'm grateful.
And then it goes all the way to 91, line 9.
It does.
Thank you.
I'm very grateful.
Now, are there any particular, is it the whole passage, or are there any elements in it?
Well, in respect of those examples I've given in the skeleton argument, you have the points we make in writing.
Yes.
And just to be clear about those, paragraph 31 makes the point that in respect of that first example, the judge pursues a line of questioning apparently designed to test Mr. Islam's evidence, that's the appellant's friend, in respect of his claim that he went to the test centre with the appellant. And that can be characterised as cross-examination, but whether one wants to characterise that as cross-examination or not, this is the judge pursuing a line of examination that we respectfully submit goes beyond merely clarificatory questions. It's pursuing the judge's own theory or line of thought, which in my submission is incompatible with the observations we saw from I think,
Sorry,
the
what's the
JK.
theory or the line of thought?
Well, the way I put it at paragraph 31 is that the judge is testing the evidence from Mr. Islam that he went to the test centre. So that must be because the judge is sceptical.
Sorry, because if you go to page 87, the judge starts by asking, why did he go with you? Are you saying that the questioning is hostile in some way, or? Because you see, the alternative perspective is the judge is filling out the account, is that the judge has concerns about the details, is asking detailed questions.
Well, that would be the role of the advocates. Both parties were represented, the court's aware of that. There are also witness statements.
Yes.
The only value of this line of questioning is to test Mr. Islam's claim, which is in his statement, and he'd been cross-examined on that he went to the test centre with the appellant. So this, in my submission, goes beyond a clarification. Effectively, the judge, no doubt out of a desire to get at the truth, but effectively the judge is pursuing her own line of questioning. And that, with respect, is a matter for the advocates. And you can see on page 88, the judge presses on this. So, bottom of 87, why did Mr. Islam go with you? Top of 88, what was the purpose of him going with you? So what did he do when? So when you went in to do the test, when he went in to do the test, I think that should be when he went in. What did he do? I think the judge has got things right. Yeah. Yeah. So the judge pursues that line of questioning. And in my submission, well, you've got the submission, that goes beyond proper function of a judge. And in respect of that second example, the point we make at paragraph 32 is that, again, we see here a line of questioning that is apparently designed to test the appellant's case. I'm sorry, I was getting confused, I think. The first example and this example is, I think, concerned with the appellant's evidence, not Mr. Islam.
It is, yeah.
It's testing.
No, I understand that.
So the second example can perhaps more easily be characterised as cross-examination because there are leading questions. And in any case, the judge is pursuing a line of questioning which was not pursued by the advocates and which we say goes beyond the proper function of a judge in asking questions. Sorry. It's on page 9.
Sorry, I may have misunderstood, Mr. Biggs. Did you say the judge was asking leading questions?
In some respects, yes. I mean, there are some, at least arguably, leading questions.
A lot of them just seem to be open questions. Oh, I see what you mean. There's the odd one, yeah.
So, for example, question:
Line
did you ever
18.
write to the college? Well, that's leading. That's suggesting he should have written to the college. But in any case, he says, no, I didn't write. Then you've got the follow up. Sorry, you did not write to the college, but now you're saying you did write to the college, but that was in 2020. And then the next question after the answer: why did you wait until 2020 before you wrote to the college? Now, it's difficult dealing with a transcript like this because I'm focusing on particular examples in the course of oral argument. The court will need to look at the entirety of the transcript, and in particular, the entirety of the judge's questioning in order to conduct its own objective evaluation. But in my submission, the extent of this questioning and the nature of the questioning clearly went beyond what the Jones principle permits, if I can put it like that. And just to give a couple of examples here, in addition to what's in the skeleton argument.
Yes.
We look at page 89. Line marking 16.
The answer,
I'm sorry, the question 15.
right.
What did you do when you got the letter? He talks about the letter. 19, did you contact the college, Queensway? I did. And then there seems to be a degree of cutting off. No, just stop there, just slow down. You contacted Queensway, tell me the date. I don't remember the date. Just a moment. You cannot remember the date? Tell me which month it was and which year. And then we see 28 and 29. It's not too long. I phoned them. Sorry, that's in respect of the question at 26. How many months after did you contact Queensway? And then we see going over to 90. I think we've already looked at this. The point about the principal.
Yes.
Line marking 10. Why did you not write to the principal? So that's the first mention of principal. You tried to contact the principal. Who was that? And then 15. Well, just a moment. You tried to contact the principal. How did you do that? Did you ask to speak to him or did you write to him? And then we see that line of questioning continuing. And then at 91, line marking 25, Judge, do you have any evidence you paid for the test? Do you have a receipt? No, I don't have anything. Why do you not have a receipt? Because I paid by cash. Well, you still get a receipt whether you pay by cash or not, so where is the receipt? Receipt, truly, I lost it. I don't think I need to come like this position, so I don't keep it. They give me small receipt, but I didn't keep it. So the judge here is pursuing a line of leading questioning in respect of receipt, not a point that had been raised by the advocate for the Secretary of State. And in respect of Mr. Islam, the judge's questions in respect of his evidence are at pages 97 to 99 for my ladies and my lord to note. And I just highlight two examples. 98. Line 25, all the way going over to line 10 on the next page, on 99. So here you've got the judge exploring when the appellant contacted the college and whether Mr. Islam knew about that. Do you know when he contacted the college, or did he contact the college? College about the allegation of deception. I'm sorry, I really don't know about these things. Why do you not know? You were his childhood friend who lived with him for many years. Why do you not know whether he contacted Queensway College to complain? And then we see some over-talking towards the bottom of 98. And then on 99 at 7, I'm not asking you whether he was serious about his studies, but this is an important question. I'm asking you whether you know whether he contacted Queensway College, and I think your answer is that you do not know. Is that right? I'm not sure. So again, difficult to get an impression from the transcript about how this questioning is proceeding. But if we go back to 98 at 25, and particularly the question at line marking 29, that does appear to be a fairly aggressive question. And then if we look briefly at Mr. Mazumdar's evidence, which for your note, my ladies and my lord, is on pages 106 to 109, this is the judge's questioning in respect to Mr. Mazumdar's evidence.
Sorry, 1 minute. Yes.
It's page 106, I think line. Let me just make sure I've got the right reference. Page 106, please. So we see that just at the beginning of the judge's questioning from line 6, there's a leading question. Was it the college in Romford he tried to take to book the test with? And we'll look at the judge's reasons in due course, but the judge does refer to Romford. And then the judge explores how the witness knew that Queensway College had available dates, which is a point the judge highlights in her decision. Because he checked online and spoke to a person as well over the phone. But how did you know? You said earlier you recommended Queensway College. No, and then you can see there's over talking. How did you know that? And then the judge at 22, sorry, I do not follow that. Tell me why you recommended. And then the judge continues to explore that. And then we see Mr. Carriam intervening, as Upper Tribunal Judge Gleeson fairly noted, at line marking 31. And then at the top of page 107, the judge responds to the intervention and continues the questioning. And then bottom of 107, when did you tell him to contact ETS? This is line marking 33. It was around 1819. Why did you advise him so late in the day? And it goes on. And again, these are just examples, and on my feet it's difficult to get the impression across that will only come from a fair objective reading of the relevant parts of this transcript in context. But in my submission, what we see in respect of these examples, and more importantly, when the transcript is considered fairly and as a whole, is that the learned judge did pursue questioning that went beyond what was appropriate with great respect for a judge of the first tier tribunal in this type of case. Bearing in mind that both parties were represented by counsel and had had the opportunity to ask the questions that they considered to be appropriate. And we do submit that the judge's descent into the arena for that, in my respectful submission, surely is what happened here. Does seem to have had some impact on the judge's analysis and decision. The judge's decision, the first tier tribunal's decision, is at page 128 of the hearing bundle. The judge analyses the evidence, in particular from, I think, paragraph 31 onwards. And the judge turns to the oral evidence from 34 in particular onwards. And if I may, I'll just make 2 or 3 points.
Sorry, wait a minute, I've just got to go there.
So it's paragraph 34 onwards for the extensive assessment of the evidence, oral evidence, page 134.
Yes.
In my submission, when one carefully considers what the learned judge writes from paragraphs 34 onwards in her decision, with the evidence recorded in the transcript, there is reason to think that the judge's ability to objectively evaluate the evidence was to some degree impacted by her descent into the arena. So just a couple of examples there. Paragraph 38, bottom of page 138. Mr. Islam said he waited outside the college for the appellant to finish the test, said he waited to 2 to 3 hours, left at 12. They then had lunch with Mr. Mazumdar between 12:30 and 1 p.m. Well, actually, I think it was 1:30 if one looks at the transcript at page 97.
Sorry, so it was 12:30 to 1:30.
Yes, I think Mr. Mazumdar said that the lunch took place at 1:30.
Sorry, this is talking about Mr. Islam's evidence.
Yes.
not Mr. Mazumder, isn't it?
Well, yes. So, Mr. Islam, what's being said is that I think Mr. Islam said they had lunch with he had lunch with the appellant and Mr. Mazumder between 12:30 and 1 p.m.
Okay,
And then there's reference to when the test finished.
yes.
There's, at the top of page 97, Mr. Islam says, he's asked what time did you go to Whitechapel after he finished his exam for lunchtime. He went to Whitechapel for lunch around 1:30.
That's the point, my lady. I'm very grateful. And then if we look at paragraph 40 for another example of where the judge's evaluation has been, dare I say, distorted because she descended into the arena. The judge says that the appellant was hesitant in his evidence about whether he asked to speak to the principal. This is paragraph 40. And the judge goes on in that passage to say that the appellant didn't give a credible explanation as to why it took him 6 years to write to the college. Well, we've looked, I think, at the passages where the judge asked questions about this. Contacting the principal, and I think also the point about delay, but certainly contacting the principal, that all came from the judge. Paragraph 42. The second part of the paragraph, I find that if the appellant was genuinely appalled that he'd been accused of deception, he would have instructed representatives in 2014 to make inquiries on his behalf with ETS, to not only verify his test results, but to provide voice recordings. Well, the appellant gave evidence about this on page 90 of the transcript. Sorry, page 90 of the bundle. I think 27, line marking 27 onwards. And in particular, you've got the question at 30. Why did you wait until 2020 before you wrote to the college? So again, this is coming from the learned judge. 31 to 33, because before I'm trying to contact, but by that time my lawyer said you no point to contact with them, because if you contact with them they can't solve anything. So they say don't, I don't have money as well. Now, the judge doesn't address that evidence anywhere. It's not addressed at paragraph 42, despite the point the judge makes at paragraph 42 that I've asked the court to look at. And actually, since we're in this part of the transcript, bottom of 90 going over to 91, I think this is an aspect of the transcript I've referred to in the skeleton argument, but I can't resist to point it out now just in case I've missed it. Line 5, it does not cost any money to send an email to ETS, does it?
Sorry, wait a minute. Line 5, page 90.
91, sorry, top of 91. The context is the question at line 1. Why did you wait to 2020 to contact ETS? So this is all relevant to para 42 of the FDT's decision. Madam, actually at that time I'm financially very poor, so if I'm going to move, have to go lawyer, need to spend money for that, I can't do it. Doesn't cost any money to send an email to ETS, does it? Now, again, not entirely obvious that whether this was aggressive or hostile or whatever, but it certainly could be read that way. That does have that feel about it, but I can't make too much out of that. But still, this is all relevant to what the judge finds at paragraph 42, And the judge did not consider the appellant's explanation for why it took him so long. For why he didn't contact ETS in 2014, which is set out clearly at line marking 31 to 33 on page 90. That is the sort of thing we see from the cases that indicates that the risk of a judge being unable to objectively evaluate the evidence has been met. The threshold of risk has been met. The final point I would make in respect of the judge's reasoning is in respect of paragraph 44 of the University Tribunal's decision. So that's page 135. So here the learned judge refers to the fact that the appellant said that Mr. Mazumdar had assisted him in preparing for the TOEIC test for 6 weeks. Sorry, that I think Mr. Mazumdar said it was 6 weeks. Appellant, on the other hand, said he was assisted for a month. But the learned judge did not bear in mind that the oral evidence involved a degree of uncertainty. So the appellant in particular said it was around a month. That's line 6 on page 89. Question, no, over how long a period did you study? Was it for a month? Was it 6 months? Was it a year? Was it 1 week? Again, this is the judge. Answer, like around 1 month. Well, around is important, particularly bearing in mind the context that this is a question from the judge. And 1 month, around a month, is not very far away from 6 weeks. And I'm afraid I can't find the reference right now, but I think Mr. Mazumdar said around 6 weeks as well. The judge doesn't deal with that evidence of uncertainty, which again is an indicator that, with great respect, the dust of conflict has distorted her ability to objectively evaluate the evidence as a judge must. So the conclusion we get to, and I reiterate, the examples I've given, there may be other good examples, there may not be, but the important thing for the court to do is to evaluate the transcript in the light of Mr. Karim's evidence as well, giving whatever weight is considered appropriate to that, applying the objective test that we've discussed in respect of this species of unfairness. And if the court, and in my submission, once that is done, it is clear that the learned judge went beyond supervisory role, accounting for the possibility of clarificatory questions, etc. And therefore, the threshold of risk has been reached in this case. The learned upper tribunal judge's decision, in my respectful submission, failed to adequately deal with this argument. All the judge said about this, so this is, the judge's decision is at 44, page 44 I think, of the hearing bundle. Begins on 44. The judge's reasons in respect of this argument are set out at paragraph 45 on page 51 and 48 on page 52. So on page 51 at paragraph 45, court will see Upper Tribunal Judge Gleeson refers to having looked through the transcript and expresses views about that. The judge formed the view that there wasn't an indication in the transcript that the judge asked questions in an aggressive manner. And then the judge refers in particular to the crosstalk with counsel, where Mr. Karim asked the judge to allow the witness to finish answering a question, which we looked at. But in my submission, this really doesn't do enough to show that the judge properly evaluated the transcript, bearing in mind the correct legal principles and the aspects of the transcript that I've tried to highlight. But on a fair reading of the transcript, we say that the Jones principle has been transgressed. And then we see paragraph 48 on page 52. If you like, the judge's key reasoning, or at least the judge's conclusion. I'll come on to this very shortly in respect of ground 2 in a bit more detail, but what the judge effectively seems to say here is that because there was no intervention by counsel at the time for the appellant, there was no procedural unfairness. The judge says there was no procedural unfairness. If there had been, advocate below would not have hesitated to say so at the hearing. Well, that's not, in my respectful submission, compatible with the objective evaluation that is required in respect of this species of unfairness. There may be lots of reasons why an advocate does not raise an objection at the time. And in this case, in any event, we had a statement from the advocate explaining why he didn't do so. But for the purposes of ground 1, the point in my respectful submission is that the learned judge did not do enough in paragraphs 45 and 48 to properly evaluate the transcript and the overall circumstances, applying the objective assessment that's necessary in this context. And my learned friend says, well, it's not enough for me to make that point. But in my submission, if we're right about that, then the upper tribunal's decision plainly cannot stand. But even if the court is of the view that the learned judge did consider and apply the objective assessment that was necessary in this case, there can only be one right answer in respect of that objective assessment. And we submit that the answer has to be that the learned judge did descend into the arena and that there was unfairness as a consequence, or the requisite risk of unfairness, at least when one considers everything in the round and applies that objective assessment. So for those reasons, we invite the court to uphold ground 1 and to allow the appeal on that basis.
Thank you.
Turning then to ground 2, which I can deal with much more quickly, I hope. Just a couple of points on the authorities. We've already looked at the Beswick case, we don't need to go back there. Can I ask the court, though, to look briefly at the PA case, which is an upper tribunal decision. Tab 10.
Yes.
The relevant passages, for my purposes, are at paragraphs 81 to 83, beginning on page 212. I think my learned friend would highlight 81. Members of the bar are expected to put their client's cases fearlessly. As a general matter, if counsel concludes during a hearing that a judge is behaving in an inappropriate matter, counsel has a duty to raise that there and then. But importantly, at 82, the fact that there's no contemporaneous objection, not determinative, I'm paraphrasing, but that's the point.
Yes.
Each case must turn on its own facts and circumstances. And then interestingly at 83, the point that's made is, well, these sorts of issues would be much more easily resolved if we had a transcript, which suggests, in my submission, that the failure to intervene, to object, I should say, by an advocate is of limited value when one has a transcript, because the reviewing court can then look through the transcript and form its own view. And of course, that's the context here. I would also just point out that these observations seem to be made in the context of apparent bias, which does involve a different test. I mean, in terms of the informed observer, reasonable.
I'm not
appearance of
sure
bias
that
test.
impacts on the point that one might expect council to raise a concern if they had a concern, to applying to both.
I think paragraph 81 has to apply as a general matter,
Yes.
and it's expressed in that way. But 82 is talking about bias, and the tests are different. It may not be that makes a vast amount of difference on the facts of this case, but the tests are different. I mean, the reason we say it might make a difference is that when it comes to the objective assessment, it is a matter for the court to form its own view in the light of all the relevant material.
Yes.
There's no possibility of waiver, for example. And so we're not dealing here with an assessment of appearances. And that might be an important difference.
What relevance is it that when asked whether he had any additional questions arising out of the questions asked by the tribunal judge, no additional questions were asked?
Well, the judge was absolutely right and fair in giving counsel the opportunity to ask further questions. And I reiterate, our case in no way suggests any kind of impropriety or bad faith. That's not necessary. We looked at Jones on that. Mr. Karim's evidence, paragraph 3 of his witness statement, is that he formed a tactical judgment, if I can put it like that it was unnecessary to ask further questions because, in his assessment, the evidence that came out was consistent. He says that's why he didn't object, but that also carries over into why he wouldn't have asked further questions.
More, I was asking about whether that impacts on an assessment, whether it's relevant to an objective assessment of the fairness or unfairness of what took place.
I think it has to be relevant. It's part of what happened, but it doesn't, in my respectful submission, undermine our argument in any way. Because if the judge has descended into the arena for a considerable period, giving the opportunity for follow-up questions at the end of that process is not going to, if you like, cure the unfairness that has arisen. The threshold of risk will have been reached. And of course, all of this case and applying the Jones principle generally is a fact-sensitive exercise. You have my submission that threshold of risk was clearly exceeded in this case. And I think my learned friend relies on Beswick, just to be clear about this. I don't think we actually looked at the passage, but I don't ask you to go back to Beswick on this. I think there's a recognition in Beswick at 27, and we did look at paragraph 27, that there is an obligation on counsel to object. Now, the question in this context is, what is the forensic significance of the absence of objection? And in my submission, bearing in mind that you have the transcript, bearing in mind the overarching point that the objective assessment is a matter for you, the fact that there was no objection is of very limited value in assessing whether the threshold of risk has been reached.
Presumably because there's a range of reasons why counsel might not have objected.
That's right.
And those reasons are not just because counsel didn't at the time think it was unfair.
That's right. And we don't need to speculate in this case, my lady, because the next point is we have the statement from the advocate that says he thought the process, that the judge's interventions were unfair, but he made a tactical decision not to raise an objection.
I don't think it's going too far in saying that one of the obligations of counsel is that if they consider that the case is going awry, becoming unfair, they need to say it, because otherwise they're not really fulfilling part of their responsibility as an advocate. I appreciate the forensic point about what you draw from it, but I think just expressing the obligation on counsel to try and ensure that the trial doesn't go off track, putting it very broadly, exists.
Counsel is obliged to act fearlessly. We have the judicial observations, which I don't invite this court to depart from.
I
but
don't
there is the
expect you to act
obligation.
fearlessly. That's it. But I know what you mean. Yes,
I mean, but this, I mean, that's, for example, what's said at para 81.
it is. It is.
So I think the point that's being made is, counsel should say if they feel that something has gone awry. All I would, and so I don't seek to persuade the court otherwise at all. Of course, that's not the issue in this case. The issue is a forensic issue. But I do say this with great respect. If counsel is confronted with a situation like the advocate below is confronted with, counsel is in a difficult position. It's not counsel's obligation is to act fearlessly. Counsel's obligation may well be, as a general matter, as is stated in the CA case, to object at the time. But counsel also has an obligation to do the best by his client. And that requires a tactical judgment. If you're confronted with a judge who has, in your assessment, behaved inappropriately, perhaps has demonstrated a degree of hostility, raising a forthright objection in circumstances where, in your view, the evidence is nevertheless consistent, may well do more harm than good as far as your client's position is concerned. And so that's what I
Yes.
feel obliged, in
Yeah.
fairness to my learned friend who appeared below, to make that point, because he was in a very difficult position. He formed a tactical judgment on his feet, so to speak. I do urge the court to bear that in mind.
No, and your submission is that if the hearing is unfair, it's unfair,
Yes,
and that's
absolutely, absolutely.
Yep.
And, yes, and and whatever one may make of so. The fact there was no objection is part of the overall circumstances that can be looked at when the court conducts its evaluation of whether the risk threshold has been met in this type of unfairness case. But it's only a part of the picture, and it may very well be that it's a fairly minor part of the picture, particularly where you have a transcript. But in this case, we had the evidence from the advocate below that explained why a decision was taken not to object at the time. And so that meant the mere fact of the absence of an objection had virtually no forensic value. And so when we go back to the upper tribunal's decision at paragraph 48, this is page 42 again, sorry, 52 of the bundle. The difficulty for upper tribunal Judge Gleeson, with great respect, is that she seems to place dispositive weight on the fact that no objection was raised. The judge seems to effectively reject the advocate's evidence on the point as to why he didn't object, without any reasoned explanation and without any evidential basis.
Yeah, so she makes a purports to make a finding about what Mr. Canning was doing and moves smartly from that finding to a finding there was no procedural unfairness.
Yes. Now,
She does seem to be treating this as determined, so is your submission.
that's my submission. And the alternative is she's certainly giving it very substantial weight.
Yeah.
Not compatible with the objective assessment required, also not open to the learned judge in the light of the evidence. I mean, how could the advocate's evidence just be swept aside with great respect like that when there's no countervailing evidence? We put in a signed witness statement to try to assist the tribunal. So that's the basis of ground 2, my ladies and my lords. And since we don't pursue ground 3, that's our appeal.
Thank you. Any questions? No. Thank you very much. Yes, Mr. Tabori.
Thank you, my lord. So, starting with ground 1. The first point I'd like to make, as I cleave fairly closely to my skeleton, but look at some of the broader range of authorities that have been put before you in the bundle and some matters that my own friend has addressed orally. The first point, as you'll have seen from my skeleton, is the fact that the mischief at which the authorities are aimed at, whether it's the older Yule and Jones or the more recent cases, is the issue of intervention and interruption of cross-examination, because it has the obvious practical impact of interrupting the flow of the cross-examination. So it's not just principle, it's not just risk, it has specific impact, which in turn undermines the advocates and therefore the party's opportunity to put their case at its highest. And we can see that from the case that my learned friend essentially starts from, which is Elise in the upper tribunal, which is authorities tab 5. I'll take you back to that.
Yes.
And if we see, so usefully these cases have head notes where they sort of summarise their principles. So the first issue there on 66 of the bundle, in order to conduct a fair hearing, cross-examination should be facilitated by the judge without undue interruption.
But I think we need to identify what the broad principle is rather than examples of how it operates in practice.
Yeah.
Because I would have thought this is an example rather than a broad principle.
Well, look, we will be taking in some of the broader statements of
Right.
principle, but I
Okay.
think the thing I'd perhaps like to add to what you have before you to make your decision is that it's very much a fact-specific issue,
Yes.
which is why it's dangerous, I would submit, from a learned friend, to encourage you to take as the threshold test, if you like, risk. The reason why there are all these judicial dicta of saying the risk is X, or of prejudice, or of descending, or of all these things, is that it's so fairness is not immutable, and so you can merely say that to do this might, on a given case, cause a problem, but it's only when we look at the facts of these cases that we really see what crosses the line. And I should probably say at this point, because it's key, is that none of these cases on their facts involve simply having asked too many questions subsequent to any examination by the advocates.
But are you submitting that too many questions or descending into the arena, to use that expression, by asking questions after the advocates have asked their questions could not amount to unfairness?
Well, you're on exactly the right track, and two of the authorities do address that. They are the Ousley J.
Right.
President cases, where he says,
No, but I'm trying to work out what your submission is. Is
Yes.
your submission, but actually I was trying to put it more in the assertive, that I didn't take your submission as being that too many questions, that you couldn't descend into the arena by asking too many questions after the advocates have asked their questions.
I think, my lord, you'd have to accept that
Yes.
it's possible.
Yeah, okay.
But if
So
we go-
again, it comes back to the objective assessment
exactly,
of what.
detail, facts,
Right.
extent.
Okay.
If we go to, just as an illustration, whilst trying to stick,
Sorry, I just wanted to clarify with the breadth of your submissions, so thank you.
yes, well, just to put it in terms of a proposition then before looking at
Yes.
Justice Ousley's decisions, it is that if you're looking at not the core mischief, if you like, of interrupting an advocate's cross-examination, derailing them, hectoring them, you'd have seen from the authorities there are cases involving that, being hostile to them, but rather in an inquisitorial, well, adversarial, absolutely accept in terms of it's part of our civil system, but to take the words from Lord Carnwath in MN, adopting on a particular opportunity or occasion a more inquisitorial approach
Yes.
within that broader context, that extent per se, absent the in extremis example, is not sufficient to cross the line into unfairness by the objective standard. You need additionally other matters. There would have to be one of the factors, quite interestingly pointed out by Mr. Justice Ousley, was about ratio. He says there's no strict ratio, but if the questions vastly exceed those of the actual advocate who's cross-examining, that might be an indicator. Or he says another factor might be the hostility of the questions. One that my lord and my lady have picked up on is the issue of whether the advocates are given another chance to ask questions about matters arising after that. These are all, it's a far more nuanced, if you like, assessment if you're looking at has there been judicial unfairness in questions subsequent to the parties' questions. There's less hard-edged, if you like, than interruptions across examination. But the cases I sort of have in mind as guide to that
Yes.
are the first is excess Kosovo, which is at tab 16, page 320. Paragraphs 33 on.
Sorry. Okay.
So first, it deals with it helpfully in a separate paragraph. So 33, questions should not be too long. There is no precise permissible ratio, but asking significantly more questions than the Home Office presenting officers, again, an indication of apparently excessive intervention with the attendant risk of apparent bias. And again, I repeat my submission that the reference to risk is just cautionary for judges. It's not saying that risk is sufficient. It's not like the old test for a systemic challenge of risk of illegality in a significant number of cases. The test is on the balance of probabilities, was there unfairness? But that's the first indicator factor at 33. 34, we accept that the tone of the questions was hostile, leading and repetitive, and contained expressions of disbelief. So that is another factor. Third, if you like, is at 35, what the questions are on. So we accept that this was on a peripheral issue, developing his own theory of the case. And so again, to go back to my point about the practicalities of this and whether it denied the advocate or and therefore one of the parties meaningful opportunity to put their case, by adopting a new theory or a totally new angle, it goes to the question of what you might have foreseen and anticipated and prepared your client for or whatever. So that's why that is relevant. And so just to apply that briefly here, the Secretary of State's representative, Miss Eva Camaro,
Yes.
her questions of the appellant spread over 9 pages of the transcript, that's 79 to 87 of your bundle, to which the tribunal judge's questions are over 5 pages, that's 87 to 91. And you have a similar ratio for the appellant's witnesses. The Secretary of State's representative's questions take place across 4 pages of the transcript for Mr. Islam, that's 94 to 97, and 6 pages for Mr. Mazumdar, and the tribunals are over 3, so 4 to 3 for Mr. Islam, and 4 for the judge in relation to Mr. Mazumdar, rather than 6 for the Secretary of State's advocate. So, of course, and as Mr. Justice Ousley says, there's no sort of rule of thumb there or whatever, no sort of strict rules there, but it is an indication. As to the tone of the questions, it cannot be said that these are at any point hostile. There's acute politeness throughout the transcript. As to the issue of peripheral issue, it can be seen from tracing the cross-examination by Miss Eva Kamara to the judge's questions that the questions asked by the judge all arise within as more specific questions arising from the broad questioning that Miss Eva Kamara maps out. Miss Eva Kamara very carefully starts from, in the case of the appellant, the beginning of the day ultimately, or why you picked a given test centre, through to how the day went, through to the subsequent. So a whole canvas of a matrix of the facts, and the judge asks questions within it, and all trained on the central single issue about, was it actually you who took the test? So there's no new, surprising, novel, peripheral, to use Mr. Justice Ousley's word, line of questioning. The second of the two decisions on this point from Mr. Justice Ousley is JK. Where Mr. Justice Ousley said at 44, JK is at 17. We see similar points that one infers the learned judge was picking up again. In
Sorry,
XF.
which paragraph?
So it begins at 43.
Thank you. Yes.
43, of course, what is said is in Iono in relation to the timing in which an adjudicator should put questions for that purpose is right. So timing point, is, of course, key, and why we should need to distinguish the cross-examination interruption mischief. An adjudicator should not interrupt examination in chief or cross-examination except in circumstances to which we've referred, or for other reasons associated with the general control of the case in the courtroom. If there are inconsistencies between documents or evidence or between answers, it's nearly always best to wait until after cross-examination and re-examination to see what matters are put. However, it's wholly legitimate for the adjudicator to ask his or her own questions on issues of inconsistency, points raised in the refusal letter, or matters which trouble the adjudicator, whether or not they are raised by the other party. So we can't be too precious, if you like, about whether it's exactly totally new, because ultimately, why would the same question be asked twice? There's going to be a degree of divergence, if you like. What is important in relation to these matters is that the adjudicator should not develop a different case. That's clearly not what's happened here. And then at 44 on page 337, we see sort of presage of the excess point we've been to already about proportion in the sentence. It is also important, however, the adjudicator should keep a sense of proportion about the questions which he or she asks. It's not for the adjudicator to take over conduct of the case. So it might be the case that in different facts, because I must reiterate it's all fact specific, that at this amount of questions, if Miss Eva Kamara had asked 3, might have been problematic, potentially. But we don't really have to determine that case. Ultimately, just these are the factors that might point the way. But you are ultimately in uncertain territory, because these facts are nothing like the cases in the authorities bundle. Just in terms of the MN Somalia point, this is at MN Somalia was at tab 12. And why I made that point, and just want to
Sorry, tab 12.
Tab 12, which is on page 232, Lord Carnwath's statement about specialist tribunals.
Oh, yes.
Yeah,
Yes.
so just to, lest it appear that I'm sort of jettisoning that, I mean, why I say it's important. Paragraph 25, in a specialist tribunal, particularly where parties are not represented, there is more scope and often more need for the judges to adopt an inquisitorial approach. So just repeating my point about, it's about what's adopted. A judge isn't wed to a specific, it may change throughout the course of the case. There may be the sitting back umpire-y approach, and then there may be the things may develop such there's a need to probe. And the point that I want to emphasise first of all is that my friend sought to confine that principle to perhaps the particular nature of those proceedings rather than the tribunal in general. But Lord Carnwath's point is about specialist tribunals generally. And he even takes it from outside of that particular tribunal altogether to another specialist tribunal. As you can see, he refers to the context of social security benefits of Baroness Hale's statement in Care and Department of Social Development. Inquisitorial rather than adversarial cooperative process of investigation in which the claimant and the department play their part. So the relevance of that is quite limited, really. It's mostly raised it to address a point made by my friend Skeleton at 26, that there was no need to engage in it because both parties were represented by qualified and able counsel. Just by doing so, the judge moved beyond the proper supervisory role of a judge in adversarial proceedings. So it ultimately goes back to the point about quantity per se being problematic without identifying any particular principle which says this is too much or not. The only thing we have on quantity is what we've now already covered, namely Justice Ousley's statements. If I could take you to next to on ground one and the principles that apply to Keenan Sargon in the Court of Appeal quite recently for Sir Geoffrey Voss, Master of the Rolls, Lady Justice similar as she then was. It's tab 2. And I think this is effectively, whilst of course you have instead of in the statement that Jones remains as a very important case and foundational, etc., from Lord Wilson, I think you effectively get more assistance in terms of the actual practicalities from Keenan Sargon. So I would endorse it as assistance to you. So if we could, so it's tab 2. If we could go to start with paragraph 57 on page 36. For the reference to another Court of Appeal judgment, Kofi Adu, and the statement from Jonathan Parker, LJ, that a first instance judge is entitled to a wide degree of latitude in the way in which he conducts proceedings in his court. And the point that this saves us going to Kofi Adu as well. Lord Justice Jonathan Parker also said there, it's quoted here, nowadays, of course, first instance judges rightly tend to be very much more proactive and interventionist than their predecessors, and the above observations, i.e. Jones and Ewell, made 50 and 60 years ago must be read in that context. And I think that is an important point, but the next point is also important. Jonathan Parker, LJ, continued, that said, it remains the case that interventions by the judge in the course of oral evidence, as opposed, so he does distinguish it from interventions during counsel's submissions.
Yes.
But the point there must be that in terms of the practicalities, that that must mean, given what is said in all the authorities, during the actual examination itself. It can't just be whilst the evidence is being taken generally, because there's no opportunity to ask questions of witnesses then, they've gone, the evidence is closed. So he must be talking about during the actual flow of questioning.
Not sure. I think that's quite a narrow reading of it, but because you acknowledge that it depends,
Absolutely, it
that
depends
there
on-
isn't a hard line.
Yes,
But I understand.
I would say probably that Lord Justice Jonathan Parker's statement is overly high level, perhaps, to the
Yeah.
specifics, because
Yeah.
there must be essentially 3 stages. There must be during the actual cross-examination, where you jump in and disrupt the flow, take over conduct, all those epithets.
Yes.
Then there must, of course, be at the other end of the spectrum, well, just questions of the advocate during submissions, which is irrelevant, really, because we're talking about the judge's ability in a specialist tribunal to ask their own questions. So we can't just be talking about that. Then there must be the middle bit, which is doing as instructed by all these cases of holding on and waiting and reserving your questions and asking them subsequently, so long as you then give the advocates a chance to ask matters arising. So Jonathan Parker, LJ, must have meant that, because otherwise it wouldn't be questions of the witnesses at all.
Because bearing in mind the rather extreme facts of that case, there are pages and pages from the transcripts of the judges' interventions.
Yes.
It may just be that you didn't have in mind the potential for a
Yes.
judge to ask questions after the end of cross-examination, simply because that wasn't an issue in the case.
Exactly. And which, on one hand, means that none of all this helps you, because you're looking at a case which isn't about those extreme facts. But then secondly, why is that? Why
Yeah.
are there no cases where they've
Yeah.
said your questions, delicately put, but about 2/3 of what the Popo asked, were just too long or too much and covered in dust, etc. It's because it just doesn't flout the same principle. It doesn't come where near it. Over the page, onto 37,
Yes.
paragraph 39.
59, no?
Paragraph 59, my lady, yes.
Yes.
On the other hand, excessive interventions by the judge during oral evidence will not necessarily render a trial unfair.
Yes.
So even if it's disrupting. Thus, in Shaw and Gruby, Patton LJ, with whom Voss C agreed, considered that the, quote, the judge's interventions, whilst always courteous, were excessive, and he should have attempted to postpone his questioning, particularly of the witness of fact, until after counsel had conducted his cross-examination, except where it was necessary to ask the witness to clarify an answer so that the judge could understand the evidence that was being given. That is exactly what happened here. You have a few clarificatory questions during, and then you have the, quite correct by that standard, postponed questions. And then on the same page, where turning to the facts of Keane and Sargon, which I say, of course, you can't look at fact in terms of precedent, but I do say that in a fairness case, which is so fact specific, that is your best guide. And we see the sort of case in which there was contravention of that principle, and we see that at 62.
Sorry, what is your best guide?
I was simply saying, my lord, that the facts of these cases,
Oh, okay.
whilst
Yeah.
it's sort of cardinal principle to just not follow factual precedent,
Yes.
etc., at least give you a guide when you are, on the other hand, only working with statements as to the risks, which don't take you too far. We can all appreciate the risks, but what matters is where have the courts found in this area which is objective, and
Yes.
so the courts decide what the level is, to look at what the courts have found to be too much. And paragraph 66, again, effectively in line what we just saw from Shaw and Gruby in 2017.
Yes.
We see essentially a statement of similar principles on this case, and this is, so a lot of searching for, and rightly took me away from granular sort of tidbits and so on to a statement of principle. Well, here you have it at 66. The ultimate question, however, is whether the judge's interventions made the trial unfair. I've already indicated the judge intervened more than was appropriate. He should have attempted to postpone his questioning of Miss Keane until after Miss Anderson had conducted her cross-examination. So at that point again, save when it was necessary to clarify the evidence being given. judicial self-restraint is required to avoid the consequences referred to above and ensure trial is fair to all involved. That said, I do not consider that the interventions either prevented the appellants from fully presenting their case at trial or impaired the judge's decision-making. So that supports my point about impact. Was it material? And it shows that even more extreme facts than ours, or rather extreme facts unlike ours, namely all those interventions during the actual cross-examination, it was found that there wasn't material unfairness. And there's the important distinction, the final four lines of paragraph 66 on that page, with the cases, which endorses my, or rather I would endorse or supports my suggestion that you should look at the facts of the cases that have crossed the line to know where the line is.
Well, they may not tell you where the line is,
No.
but they'll tell you what's one side of the other of the line.
Yes, yeah, roughly, yeah. An allied point, which I'd like to make next, is to be taken from, well, we have it from Keeling and Sagan already, but just to clarify or confirm, reiterate where you get it from, it's, was that paragraph 57, the point about a certain judicial.
Sorry, 57 of this.
You've seen this already in law, but just to clarify where you saw it, it's 57 of Keeling and Sagan, page
Right.
36 of the authorities. It's,
Yeah.
it's the principle as to a degree of latitude. So even though it's not, for instance, a sort of Wensbury test or a fact-finding ambit, nonetheless, even here, with its objective test that you are to apply, there is the quote from Jonathan Parker, LJ, wide degree of latitude in the way he conducts proceedings in his court. And we see a similar point in the case of Hadi Jamaldeen at tab 13.
Sorry, wait a minute.
That begins at page 243, it's tab 13. And within it, paragraph 31.
Sorry, could you give me that again?
Yes, it's tab 13,
Yes.
and it's paragraph 31. So if you don't mind, I will go through it and read it to you rather than do the interpretations for you to read it, just so I can say, tell you why I think it's particularly relevant. So he deals with grounds of complaint in turn, and the first is excessive interruption and intervention during cross-examination. So I've been taken to many passages in the transcript. I've read and reread the whole of the transcript, particular passages to which attention is drawn must be assessed in light of the transcript read as a whole. My conclusion at the end of the day, but without hesitation, is that this ground of appeal is not made out. Significant amount of intervention by the recorder, but does not give rise to any proper ground of complaint. Stayed well within the boundaries described in Jones. His interventions were justified. He didn't take over the examination or cross-examination of the witnesses. Nor, I emphasise, is there anything in the transcript which he begins to suggest that Professor Rees was not able to put his case properly, going back to impact and materiality and being asked whether you have anything to add, or ultimately being able to say, I'm not happy with what you're doing. And the final sentence, on the contrary, as we've seen, one of the recorder's concerns was that Professor Rees was failing to put his case properly, and not, I emphasise, because the recorder was preventing him. It's that question of being prevented. But because I think just at that point, to make a point, my lord, my ladies, is that there is a danger here, not just of the sort of interest in protecting fair proceedings, which of course you are to guard jealousy, but that the claimant, an appellant who's unhappy with the outcome of a particular result, and that the question, I think it was Mr. Justice Ousley, one of Mr. Justice Ousley's statements said that the mere fact that it didn't work out for you upon that probing of the evidence isn't without more unfair, and that the danger of telling a judge who is ultimately in a specialist tribunal to ask less questions where they're not infringing on any of these things, these guardrails, is potentially dangerous ultimately, in terms of particularly something as serious as was fraud conducted here, and complex matters that require assessment. So I think that does need to be stressed.
Stress, sorry, say that again, stress what?
I was trying to express the point that you have almost sort of twin principles here, if you like. One is the fairness one, that of course procedurally that must be protected, and we have these cases sort of saying what's not on.
Yes.
But the other public interest, if you like, almost principle that exists alongside of this is the justice principle, and getting to the truth, and the specialist judge being able to ask questions so long as they don't prevent the parties from asking theirs, or terrorising the witness or something like that. And if taken too far, as I would respectfully submit my learned friend does, by setting the threshold at risk, for instance, amongst other points, is that interest is weakened, and the balance between them, if you like, is out of kilter.
Is that a convenient moment?
Yes, it is.
Is it? Yes.
It's fairly convenient.
Yeah.
Yes. I've got a bit, probably another
Sufficiently
more left
convenient.
on ground one to press on into past 1 o'clock.
Okay.
So.
Can I ask, how much longer do you think you'll be? Just very, very roughly.
Another 45 minutes top.
Okay, thank you. So we'll start again at 2 o'clock.